Hello, everyone. It's great to be back with you. It's August 8th. Here in New York City, it's kind of gloomy, but sun is breaking through, which we're glad about. Certainly feels like we are in the middle of the summer here. I know around the state, some of you are experiencing extreme weather, so please stay safe above all. We have a full program today. And we should walk through the agenda, please, Kathy. Thank you very much for that. And I can let everybody know what we're going to try to tackle. First, we'll have Roger Bearden from Albany, and he'll be talking about this new healthcare transactions requirement in New York that went into effect earlier this month. Then Mia Delane-Gurley is back on the program, like Roger, been on before, and Mia will be with us from Garden City, and we'll be highlighting Board of Regents amendments that also were effective earlier this month for those of you in education, particularly of interest. Emily Fallon, also in Garden City, down the hall, will be addressing practical guidance involving Native American representations in public schools, an interesting topic for sure. Katie McGraw up in Buffalo will cover a really interesting case that she played a role in and that we thought you would all enjoy learning a little bit more about. And we'll let her share those details. And then Kristen Warner in Rochester will be also addressing an education issue, in particular concerning compliance, and we'll let Kristen go through those details as well. But for now, Roger, who's my colleague in the Health and Long-Term Care Practice Group, will be here to share information about this healthcare transactions disclosure standard, which is pretty important for those of us in the healthcare space. So Roger, looking forward to learning along with you, and thank you for taking this time to present.
Thanks so much, Gabe. And this is part of, I think, an ongoing effort to address what both on a federal and a state level has been considered to potentially be an overconcentration in the healthcare industry, and also the role of equity investments in healthcare entities. And this started as a proposal initially to require state approval that was watered down considerably in the process of the discussions that led to the enactment of the final law to be a disclosure law, still important because it's going to create certain timelines for those who are engaging in transactions in this space. So if I could get the next slide. So as I said, so this was part of the enacted budget for the year 23-24. And as folks may know, the budget often contains not only matters of how much money the state's going to spend, but also elements around policy. And this is one of those examples. Created a new public health law, section 45A, and that it was effective as of August 1st, so about a week ago. So it's requiring that certain healthcare entities, and we'll get into that, what those entities are, to submit a 30-day pre-closing notice to the State Department of Health of certain material transactions. And then two things will happen. The Department of Health is going to transmit that to the New York State Attorney General's office, which has authority to look at antitrust issues, if any, as well as posting a summary on the DOH website with an opportunity for public comment. So if we'll go to the next slide, please. So a material transaction, and I think these slides will be made available, so I won't read them word for word, but there's things like a merger of a healthcare entity, an acquisition, an affiliation, formation of a partnership, a joint venture, accountable care organization, a management services organization, and a variety of other affiliations that people in the healthcare space fairly routinely engage in. So if we can go to the next slide. There are some exclusions. There's a sort of a narrow one having to do with clinical affiliations. And then there's also an exclusion for transactions that are already subject to the con process certificate of need process or another review process. So there are a variety of regulatory regimes that require the state either to approve or to be noticed of transactions. And so those are not included. And then de minimis transactions, which is defined to mean a transaction resulting in a healthcare entity increasing gross in-state revenues by less than $25 million. What does that mean exactly? That's a pretty open question at this moment. Next slide. So they define a number of healthcare entities, physician practices groups, a management services organization, provider-sponsored organization. It excludes insurers and pharmacy benefit managers. Once again, there's going to be a fair amount of parsing what is meant, and what does not exist yet is any regulation or sub-regulatory guidance to support this new law, though it's in effect. So there's a lot of open questions at this point as to exactly who will be covered and how they will be regulated. Next slide, please. And then there's the statute says that the notice must include a variety of mandatory information, names and addresses of the parties' transactions, copies of the agreements, locations impacts, plans to reduce or eliminate services, a closing date, and then next slide, please. And the description of the purpose of the transaction is going to be, I think, particularly interesting with anticipated impacts on cost, quality, access, health equity, and then anything that's being done to address those impacts. So really, you're getting there to kind of the meat of the concern, right? Which is if there are these transactions that may negatively impact health equity, that may negatively impact consumer choice. These are things that would need to be identified and mitigating measures identified. And once again, if you recall this, there's a summary that would be proposed and published by the Department of Health. And there's this comment of what's going to happen with that comment. And I think is kind of an open question at this point. Next slide, please. So as I noted, the law is effective. If you go to the DOH website, you can just kind of get an outline of the website, and they've established an email address that I include in the presentation where these submissions are going to occur. There's an intention for forms to be developed, probably regulations, probably sub-regulatory guidance. And we're a little bit in a space right now where there's more unknowns than knowns, but I think the purpose here in bringing it to this audience is if you're in these spaces and you're interacting with entities, if you're contemplating transactions, you really do need to be thinking that there will be disclosures, there will be delays built in, and then the potentially greater attention, particularly public attention, to the transactions, which may impact what transactions are pursued and also the scope of them. So I think I'm at the end of the slides, and I can't see whether any questions came in, but I'm certainly able to address or pass on to the next speaker.
So Roger, one did, and it is about whether this all will impact IPAs. And then there's another one that just came in on Medicare direct care entities, essentially wondering if they'll be affected. My thinking is there should be an assumption that yes, they will be in both instances. I don't know if you see it differently.
I think that is likely. I think where the Medicare direct care entities, I would want to give a little thought to it simply because if it's a purely federal entity, there may be some reason to believe the state would not interfere. But I don't know that that's. I would want to think about that. And there's a second piece of that question, which is any impact on healthcare organizations becoming investments on Wall Street. And I do think that there's, as this becomes understood, certainly pricing into any transaction the possibility and the likelihood of public disclosure, right? That may be something that may be disadvantageous or advantageous to a particular transaction. So I think there's going to be some thought. I think the origins of this really lie with the role of private equity in healthcare and concerns that have been brought from various consumer advocates around that. So I think that there's certainly an intended impact. Whether it has the impact, I think is an open question. And I should mention as well, there are at least a half dozen other states I'm aware of that have some version of this kind of law, and they're all different. So multi-state transactions are going to be particularly interesting, where they're all navigating these different regimes.
Roger, that's really helpful. And for those of you who are involved in healthcare activity generally, our practice group looks forward to pitching in and allowing you to have some guidance and support as you navigate this all. But Roger, really appreciate your efforts to introduce this group to these new standards. Thank you. And please come back on the program. I should note that Roger is a senior counsel in the Albany office, and we'll be switching now to another senior counsel, Mia Delane Gurley, who is in Garden City. Mia has been on the program previously. Mia focuses on education and has also worked in New York City government. We share that background. And what you see here are you'll see in a moment a slide or two from Mia that will be about Board of Regents amendments that also went effective earlier this month. And we thought they were timely. And for those of you in the education space, we want to ensure that you learned a bit more. So Mia, the floor is yours, and welcome back.
Thank you, Gabe. And good afternoon, everyone. So like Gabe said, amendments to Section 19.5 of the Rules of the Board of Regents and Sections 100.2, 200.1, 200.7, 200.15, and 200.22 of the regulations of the Commissioner of Education related to the prohibition of corporal punishment, aversive interventions, prone restraint and seclusion, the limited authorized use of timeout and restraint and data collection applicable to students with and without disabilities became effective on August 2nd, 2023. And today I'd like to highlight the relevant aspects of those amendments. So Section 19.5 of the Rules of the Board of Regents is now expanded beyond the prohibition of corporal punishment and aversive interventions to also prohibit seclusion and prone restraint. Those same rules of the Board of Regents now indicate when and how timeout and physical restraint may be utilized, and now requires same-day notification to parents and persons in parental relation following the use of timeout and/or physical restraint, maintenance of documentation of each incident involving the use of timeout or physical restraint, a debrief between school administrators or designees after each incident in which a timeout and/or physical restraint is used, regular review of documentation between school administrators or designees on the use of timeout and physical restraint, written policy establishing administrative practices and procedures regarding the use of timeout and physical restraint must be adopted by schools, be made public and posted on the school's website if one exists. There's now a requirement for annual training on the school's policies and procedures related to the use of timeout and physical restraint for all staff. There's also a requirement for annual evidence-based training in safe and effective timeout and physical restraint procedures for any staff member who may be called upon to implement timeout or physical restraint. Section 19.5 of the Rules of the Board of Regents and Section 100.2 of the Commissioner's Regulations now include an annual reporting requirement beginning with the 2024-2025 school year, which indicates that schools will be required to annually report on the use of physical restraint and timeout, substantiated and unsubstantiated allegations of use of corporal punishment, mechanical restraint, and other aversive interventions, prone physical restraint, and seclusion, and schools will be required to submit electronic records on the use of corporal punishment for each student who was placed out of the district for educational services by the district's Committee on Preschool Special Education. The other relevant sections of the commissioner's regulations that were amended include section 200.1, which was amended to revise the definition of aversive intervention consistent with the definition in section 19.5, which defines an aversive intervention as an intervention that is intended to induce pain or discomfort for the purpose of eliminating or reducing student behavior. Section 200.7, which was also amended, and it added the use of corporal punishment and seclusion to the list of unauthorized behavioral interventions that, if used by an approved private school, can result in denial or approval of reimbursement of public funds. This amendment also added corporal punishment and seclusion to the list of prohibited behavioral techniques used by approved preschool programs, approved private schools serving school-age students with disabilities, state-operated schools, or state-supported schools to reduce or eliminate behaviors of students. Section 200.5 of the Commissioner's regulations was amended to replace the term emergency intervention with physical restraint, and the term timeout room was replaced with just timeout. Finally, section 200.22 of the Commissioner's regulations was amended to, among other things, remove references to child-specific exceptions for the use of aversive interventions and add corporal punishment, seclusion, and physical restraints to the list of interventions that cannot be included on a student's behavioral intervention plan. It also added the requirement that timeout must be used in conjunction with the behavior intervention plan, except for situations that create an immediate concern for the physical safety of a student or others. It removes any child-specific exception to the use of aversive interventions to reduce or modify student behaviors. And finally, it removes program standards for the use of aversive interventions. I want to thank you for your time today, and I hope that the information I presented today was helpful.
Mia, thank you very much. I have two questions for you.
Yes.
So first, consistent with what Roger was speaking about in terms of the policy behind the changes, what do you think spurred all of this? So that's question one. And then question two is, what should bond clients be thinking about as they respond to these changes? What are some of the highlights that they should walk away with?
Yeah, I think part of what spurned all of this was there was actually something went public in the Albany Times-Union in fall of 2022. They did a years-long investigation into the use of timeout, seclusion, and restraint in New York State schools. And I think that spurned a lot of this. Then there was something by the US DOE, the federal government, encouraging all governors to preclude the use of corporal punishment that was issued in March of 2023. And, there have been laws passed in 2022 by the New York State governor that encouraged or required Board of Educations to notify parents about the use of physical restraints or mechanical restraints. And I think at this point, the Board of Regents said we need to, codify this and put this into law. Your second question in terms of what our clients should be thinking about is there's a lot of work that has to be done beginning with this school year. I think what's really important is the requirements for trainings. So because it's going to be required on an annual basis, I think clients should think about when they want to hold those trainings and identify the staff that should participate in those trainings. And then think about the requirements that for all staff that have to be trained and get those dates on the calendar. I think the client should also be mindful of those students that they are aware of that may have a physical restraint listed in their behavior intervention plan, and where that is listed, there's going to be a need to revisit that recommendation since it's no longer allowed under the law, and where schools may have been using timeout, now that it's required to be used or included in a behavior intervention plan, except for those limited situations where there's immediate concern for the physical safety of a student, they're going to need to revisit those students' behavior intervention plans and make sure that timeout is incorporated as appropriate.
Wonderful. That's really helpful. There are a couple questions that came in through the chat. So if Mia, you're able to address those offline, that would be terrific. And again, thank you for joining us. And let us turn now to our third presenter for the day. And that will be Emily Fallon, who's an associate as well in Garden City. Emily's been on our program before, and we're delighted to have her back. And she also works in the education space and is ready to talk about Native American representations, which is, of course, a very complicated national story. And we're seeing lots of change, whether sports teams or otherwise, being rebranded in ways that are intended to connote respect and deference to, cultures that, are, very much in the minds of many as underrepresented and underappreciated. Now what we're seeing is some of the changes in schools, and Emily's here to talk about that. So Emily, looking forward to hearing what you have to say, and please go right ahead. I look forward to learning along with the audience.
Good afternoon, everyone. I'm happy to speak with you today about the recent amendments to the education law prohibiting the use of Native American mascots and foods.
And Emily, your audio is a little fuzzy. I don't know if there's something you might adjust.
Is this better?
Yeah, if you were just able to speak a little bit more closely to your mic, I think that'd be terrific. Thank you.
Sure, thanks, Gabe. Next slide, please. So in November of 2022, the New York State Education Department released a memorandum stating that public school districts are prohibited from utilizing Native American mascots and must commit to changing them by the end of the 2022-2023 academic year. The push to replace mascots and team names associated with Native American culture has been a conversation within the State Ed Department since 2001, but the November 2022 memorandum was the earliest policy position taken by the state. This probably won't come as a surprise to many, but once this memorandum was released in November, school districts across the state had many questions with little practical guidance on how to begin planning for compliance, being that they put the end of the 23 school year as a deadline. So finally, on May 3rd, 2023, Part 123 was formally adopted and provided specific parameters on what the regulation and the amendments would mean for school districts moving forward. Next slide, please. Simply put, the May 3rd guidance required that by, like I mentioned, this past June 30th, 2023, school districts with team names, mascots, and logos that have any connection to Indigenous peoples must adopt a board resolution committing to eliminate the use of all such names, logos, and mascots by June 30th of 2025. The amendment expressly bans the use of symbols associated with Indigenous peoples such as feathers, historical weapons, like tomahawks and spears, or logos utilizing stylizations that are generally associated with Indigenous peoples, such as feathers or traditional Indigenous clothing. Next slide, please. So for purposes of today's webinar, it's more digestible to begin thinking about what Part 123 doesn't cover. So the regulation doesn't apply to any tangible legacy or memorial items that are displayed in public schools, like plaques, trophies, medals. Further, public school buildings, school districts, or towns named after local Indigenous nations or tribes are outside of the scope of Part 123. So, for example, if a school building in your district is named after a local Native American tribe, the school itself does not have to be renamed or rebranded. The regulation only applies to team names, mascots, and logos. Next slide, please. So the big day-to-day practical implications of Part 123 is that school district employees are expressly prohibited from displaying paraphernalia or clothing associated with the retired Indigenous name or mascot. So the practical implication of this is we can imagine a situation where a teacher is a coach and one day decides to wear a sweatshirt or some sort of spirit wear from a prior season that has the retired name or logo. That is per se a violation of Part 123. And on a larger scale, the amendments require that gym floors, turf fields, or other facility-related items that display the retired name all must be removed and replaced. Next slide, please. So the State Education Department has recognized that these facility replacements are a major undertaking for districts, both with planning and budgetary restraints, and have provided that districts should take what they're labeling as an economical approach to comply with the regulation by June 30th of 2025. So to them, this means that if a district has a turf field that, let's say, displays an Indigenous team name or mascot embedded in the turf on the end zones or in the center of the field, rather than replacing the entire turf field or the entire gym floor, just replace those specific areas. So if an end zone on a turf field says an Indigenous name, just replace those. If the center of a turf field displays a Native American headdress or any other mascot or logo associated, just replace that part. And recognizing that this is a large financial undertaking, the state education department is providing the opportunity for districts to obtain some building aid upon application. Next slide, please. So a frequently asked bottom line question about the Part 123 amendments is that what happens to a school district that chooses intentionally not to comply? And the Commissioner of Education has taken the position that compliance with Part 123 should be managed by local leadership, but will take action if a district or their Board of Education will not take the necessary steps to ensure compliance on their own. This includes removal of school officers and officials and withholding of state aid. Next slide, please. So even though we're talking about this on August 8th of 2023 and June 30th of 2025 seems very far away, compliance with Part 123 takes a lot of planning on the part of school districts, and with planning comes the opportunity for a lot of hiccups and unanticipated issues along the way. So therefore, upon a showing of good cause, the state education department has offered the opportunity to grant an extension to comply with the deadline past June 30th of 25 upon application, with showing that, let's say there's an inability of specific individuals, let's say contractors or consultants, to complete specific work on time, and demonstrating that substantial progress has already been made is a per se showing of good cause, reason for extension. If replacement costs could be substantially mitigated if they are postponed past the June 30th, 2025 deadline, or if the district were to provide an attestation that work completing towards a capital project is ongoing and substantial progress has been made to be completed by the past the 24-25 academic school year. And to request an extension, districts should apply with the state education department, including an explanation as to why the extension is needed, a timeline of all definitive actions taken to date, and to eliminate the use, or a timeline of all the actions that the district has taken to date to eliminate all the use of prohibited names, logos, and mascots pursuant to the regulation, and a commitment by the Board of Education as to that date by which the use of prohibited names, logos, and mascots will be eliminated. And there are a lot of practical realities that have yet to be addressed by the state education department as we continue to navigate our way through these amendments. If you ever have any questions, please don't hesitate to reach out to the Baum School Law attorney that you are most familiar with to discuss any of questions.
And Emily, thank you very much for your presentation. To the audience, sorry, the audio was a little bit up and down, but the slides will be provided certainly to everyone who wishes to download them. And let me just also add that, as Emily noted in her presentation, while it is August 8th of 2025 will sneak up on us. And for those districts that need to think about this issue and the various branding aspects and approvals that come with it, now is the time. And so please reach out to the education attorney that you feel most comfortable with, and we look forward to helping if we can. Let me turn next to Katie McGraw, who's here with us from Buffalo. And we're shifting away from education for a moment. And what we're going to hear about instead now is from Katie's perspective about a really interesting case that she was involved with in connection with the New York State Division of Human Rights, where there was an allegation of employment discrimination and harassment. We thought it would just be worth all of you understanding the kinds of elements and texture that sometimes are part of what we do here at Bond on behalf of all of you. And so we wanted to give Katie a chance just to talk through what happened. So Katie, thank you for taking this time, and please, the floor is yours as well. Welcome to the program.
Sure, thank you. Can you hear me okay?
Yes, we're hearing you.
All right, yeah. So yeah, thanks, Gabe. This case kind of has a little bit of everything. So I've been involved in it since its inception, and I'm still involved in it. So I'm just gonna kind of walk through all the different levels that this has been through in agencies and courts in the state, and then where it landed or where it's going. So this case began with a complaint filed by a Catholic priest against the diocese for employment discrimination. The allegations were related to race and ethnicity, national origin. And they included both claims of harassment or hostile work environment, and then also claimed that he was terminated from his employment. At the agency level, so at the New York State Division of Human Rights, where the complaint was originally filed, the diocese argued, and the Division of Human Rights agreed, that a constitutional principle known as the ministerial exception applied and barred his claims of both discrimination and harassment and termination. So the ministerial exception is what's called a penumbra of the First Amendment to the United States Constitution. It has been recognized by the United States Supreme Court in 2012 in a seminal case. It's called Hosanna Tabor Evangelical Lutheran Church versus EEOC. And in that case, the Supreme Court held that under the United States Constitution, religious employers must be permitted to make hiring and firing decisions for their ministers. So these are people employed in clerical roles. This does not apply to lay employees. But the Supreme Court basically said, because of First Amendment principles of free exercise clause and the entanglement clause, courts should not get involved in these religious disputes. So back to the Division of Human Rights, the diocese made this argument, and the division agreed and dismissed the priest's claim of both discrimination or harassment and termination. And he filed an appeal to the New York State Supreme Court, Erie County. So the standard of review for Erie County to determine whether the division was correct or not was whether the division acted arbitrarily and capriciously. So this is similar to the Article 78 standard of review, if anybody is familiar with that. The appeal just happened to come under Section 298 of the executive law, but it's the same standard of review. So now in Supreme Court, the Supreme Court was asked to decide, did the Division of Human Rights make a non-arbitrary and capricious determination that it couldn't hear the priest's claim because of the ministerial exception? And what the Erie County Supreme Court did was split up the two different claims. So took the termination claim and the harassment claim and treated them differently. And the Supreme Court dismissed the termination claim, said, nope, it is clear. The Supreme Court of the United States in the Hosanna Tabor case said that termination claims, so a firing claim, is governed by this ministerial exception. So employment discrimination claims based on termination cannot be reviewed by a court, or are not actionable, rather. But the Supreme Court said that the aspect of this priest's case that had harassment allegations was reviewable by the Division of Human Rights. And the reasoning that the Supreme Court made was that there is unsettled constitutional law in the country and in New York State as to whether the ministerial exception applies to claims of harassment or hostile work environment. So we ended up doing multiple rounds of subsequent briefing where we argued it doesn't really matter that there's a circuit split or courts are split on this issue. The Division of Human Rights was permitted to make its own determination based on its jurisdictional bounds, whether it could hear the case or not. And the Supreme Court disagreed, and the Supreme Court remanded the case back to the Division of Human Rights and ordered them to make a determination on the merits of the priest's harassment claim. The diocese and the Division of Human Rights filed an appeal of the Supreme Court's order. The Division of Human Rights, because of the appeal from the original determination, was a respondent all the way along. So this case is litigated both on the respondent side by the diocese and the division. So at the appellate division at the Fourth Department, the only issue left to determine was did the Supreme Court properly remand the harassment claim? And the diocese and the division's argument was no, it was improper to basically force the division to hear the case because the Division of Human Rights gets to decide which side of the circuit split they wanted to land on. So, and what's important in this case is that there is a federal circuit. So the federal circuit courts are split on the issue of whether the ministerial exception applies to harassment claims. There is no decision from the Second Circuit, which is the geographical circuit where we are located, and there is no New York law on the issue. So the Court of Appeals in New York has not decided the issue. No appellate divisions have decided the issue. And as far as we can tell, there's no Supreme Courts that have decided this issue. So this was a question where the division was operating on, split authority and no controlling authority. And to the Fourth Department, the arguments by the diocese and the division were the division gets to decide how it wants to decide the case. So if they want to align themselves with one side of the circuit split and not the other, that cannot be arbitrary and capricious as a matter of law. The mere fact that there's not controlling authority is not an error. And the argument there was they had to pick a side, and it wasn't arbitrary and capricious for them to decide that it did not apply to harassment claims. And the Fourth Department in June agreed with the diocese and the Division of Human Rights and said it was not arbitrary and capricious for the Division of Human Rights to determine that within its own jurisdiction that it could not hear the priest's claim. The Fourth Department, gave the appropriate deference that agencies in New York are given in administrative determinations and basically affirmed the division's holding. So that is where the case stands now. However, I will say with the caveat, stay tuned. The priest had, the petitioner priest, he has made an application to the Court of Appeals, which is the highest court in New York State. And that is where the case stands. It will be, it is being litigated there at the time. And stay tuned is all I have to say on that.
Well, Katie, thank you so much for walking the audience through what is a really fascinating procedural path, let alone a set of issues that really exhibit the kind of depth and texture that we get involved with here at the firm. And so thank you for giving the audience some insight into that. And again, welcome to the program and looking forward to having you back. And why don't we now turn then to our final speaker for the afternoon. And that is Kristen Warner, who's with us from Rochester. And Kristen, we're delighted that you can provide some guidance concerning education law in Section 2D. It's an important time as we're in the summer gearing up for fall for educational institutions to be on their toes, as it were. And as we've heard throughout this afternoon's broadcast, there are lots of issues out there. And here's another set for all of you to think about. And thank you very much, Kristen, for making this time.
Thanks, Gabe, and good afternoon to everybody. So what I'm going to talk about today is Education Law 2D, which some of you may know affects school districts, BOCES, charter schools, and certain special education schools, private schools that are registered with NYSED. Education Law 2D went into effect back in 2020, and it's the state's data privacy for school districts law. So it identifies data that exists, how it's handled, what you're allowed to do with it, and puts a lot of additional security requirements on educational entities. On July 19th of this year, NYSED sent out a guidance document to school districts, BOCES, charter schools, and other affected entities, saying that they're finally going to start monitoring education entities' websites for compliance with both 2D and with certain FERPA regulations. Now, whether the state education department has the authority to monitor and audit FERPA compliance is kind of an open issue, but they have traditionally cited to issues with FERPA compliance in the chief privacy officer's determinations on data privacy and security. So beginning in the fall of this year, they're going to start basically checking school districts and charter schools and BOCES websites to make sure that all of the information that's required to be posted there by 2D is actually posted there. So what are they going to be looking for? Mainly, they're going to be looking for three things on your website. So that's going to be whether your website has a parent's bill of rights, which must include but is not limited to information as to how parents or eligible students can file a complaint regarding the information collected by third-party vendors. You're also going to need the supplemental information for all of your third-party contracts where the contractor is going to be receiving student data or principal or teacher APPR related data. For the most part, it's the student data that triggers, that is triggered by these agreements. So PII is defined very, very broadly under 2D. It includes anything from students' names to their picture to, you know, a social security number or a student ID number. So anytime a third-party vendor is receiving any type of data under an agreement with the district, you have to have the third-party vendor fill out an additional, either it comes in the form of a 2D rider, or sometimes they'll just provide their own data privacy agreement. So that information then has to be posted onto your website for everybody to be able to access. And then you also have to have your own data security and privacy policy posted on the website in easy to find location. Usually it'll be under your tech department's site. And this should implement the requirements of the EdLaw 2D regulations found in Part 21. And it has to align with the NIST CSF standards, which is very technical jargon for what kind of security you have to have surrounding your data. Then for the FERPA compliance piece, they've indicated that they're going to be looking to ensure that your FERPA annual notification, your directory information policy, and your parent opt-out forms are available on the website. So those kind of go hand in hand with what is required under 2D. FERPA is the federal version of a policy that protects student information and records disclosures. So you're going to want to make sure that those are all available and easily accessible as well. And then finally, they're also going to be looking for some other compliance issues, such as they're going to want to make sure that your data protection officer's contact information is up to date and accurate. So that usually is contained within the parent's bill of rights, which is posted on the website. So they may be contacting you to ask for that. They're also planning on reaching out to certain entities and asking them to share information regarding their annual data privacy and security awareness training that is also required under EdLaw 2D. That's found at section 121.7 of the regulations. And they might be looking for training sign-in sheets, certificates of completion, dates of training, the training itself, or the name of the training service. So these are all things that you're going to want to have handy in case you are one of the entities that's chosen to be contacted by the state ed's privacy office. Now we at Bond in the education law practice group, we would be happy to conduct an audit of your compliance with 2D, or we can also provide the required training in various formats: person, live, virtual, taped virtual, along with providing the supporting documentation. So if you have any additional questions or would like to have us do an audit of your website or provide any training, you can reach out to me or any of the attorneys in the school law practice group, and we would be happy to walk you through the process.
Kristen, thank you. That's really informative. And I don't need to ask the question I was going to, which was, what should the audience do? You provided very clear direction in terms of where to go from here and how to take what you have shared with the group and figure out, well, how do I come into compliance and how do I prepare? So thank you for that. And if we could go then to our final slide, please, Kathy. Let me just make sure that the audience knows where to reach the various speakers today. And you can email any of us, of course. I'm going to be back with you on the 22nd. In the interim, Kristen Smith will be your host on the 15th. and wishing you in the meanwhile a very enjoyable August. For any of you that's taking a little time away, please enjoy that too. And I look forward to seeing you in 2 weeks. And all of you, please tune in next week for the program. In the meanwhile, have a great afternoon.